Welcome to the Courtroom Club. As your colleagues here at Jonker Vorster Attorneys, we know that when you're faced with the loss of a loved one, well, the last thing you need is to feel lost in a maze of legal jargon, especially when it comes to something as significant as property. That's why we wanted to take some time today for a deep dive into the ins and outs of deceased estate property transfer right here in South Africa. Think of this as us sharing some of the key insights we've gained, from years of helping families navigate this exact process. Our goal today is simple, to make this often complicated area clearer, to shed light on what's involved, what it might cost, and importantly, why having experienced legal support is so crucial for a smooth transfer. Okay, let's get into it. When we talk about deceased estate property transfer, what exactly are we looking at in practical terms?
Right. Essentially, it's the legal journey that a property takes when its owner passes away.
Hmm.
It's about, well, ultimately leading to the transfer of ownership to the rightful beneficiaries. Now, this isn't just about signing a few papers, not at all. South African law, primarily through the Administration of Estates Act of 1965, lays out a very specific path we need to follow. And this is always under the watchful eye of the Master of the High Court.
Hmm.
What's interesting, though, is that the specifics of this path can vary slightly depending on one key factor:
And what's that?
whether or not the deceased actually left a valid will.
So if there's a will, it's maybe more straightforward. Is that fair to say?
In a way, yes. If there's a valid will, the deceased will have named their intended beneficiaries for their assets, including any property. The transfer process then, largely follows those instructions laid out right there in the will.
And if there's no will, that sounds like it could get complicated.
That's when the rules of intestate succession kick in.
Intestate succession, right.
Exactly. In the absence of a will, South African law has a set formula. It determines how the deceased's assets, property included, are distributed among their surviving relatives. The crucial thing to remember, though, is that whether there's a will or not, strict adherence to the legal requirements is absolutely essential
Essential why?
to ensure that the property ends up in the correct hands, that it goes to the rightful heirs according to law.
Okay, that makes sense. So let's walk through it. Someone passes away. What's the very first thing that needs to happen to sort of get the ball rolling on a property transfer?
The initial step, and it's a vital one, is reporting the deceased estate to the Master of the High Court.
Reporting the estate. Got it.
This responsibility falls squarely on the shoulders of the executor of the estate.
And is there a time frame for that? How quickly does that need to happen?
Yes, there is. The law requires the executor to report the estate within 14 days of the date of death.
14 days. Okay.
This formal notification is what officially starts the whole legal process. And at this stage, a number of important documents need to be gathered and submitted to the master.
Like what sort of documents are we talking about?
Well, typically you'll need the death certificate, the original will if one exists, of course.
Mhm.
Also, ID documents for both the deceased and the potential heirs, a comprehensive inventory of all the deceased's assets, and the nomination of the executor.
Okay, quite a few things to gather right at the start.
Yes, absolutely.
Then who officially takes charge of the estate administration? Who makes that call?
The Master of the High Court formally appoints the executor. This is a really significant appointment
Why is that?
because the executor becomes the central figure. They're responsible for managing the entire estate. That means everything from settling outstanding debts to, crucially for our discussion today, overseeing the actual transfer of the property.
Right. Who can actually be appointed as an executor? It sounds like a role that needs someone pretty capable.
Absolutely.
Hmm.
Executors can be attorneys, and naturally we at Jonker Vorster Attorneys often serve in this capacity, given our expertise in estate law. But family members or, say, professional estate administrators can also be appointed. The key is that they are deemed competent to handle the legal and financial complexities involved.
Okay. So once an executor is officially in place, what are the next practical steps concerning the property itself?
The next key steps really involve, first, determining the property's value. This is needed for estate duty purposes.
Mhm.
And simultaneously, the executor must set about obtaining several crucial clearance certificates.
Clearance certificate.
Think of these as official stamps of approval. They're needed before the transfer can actually go through.
Which clearance certificates are absolutely essential, the non-negotiables?
Okay, there are a few that are definitely non-negotiable. First, you need a municipal rates clearance certificate.
Okay, from the local council.
Exactly. This confirms that all outstanding property rates and taxes have been paid up to a certain date. Then, we need a transfer duty clearance from SARS, the South African Revenue Service.
Right. Now, I thought you said inheritance wasn't subject to transfer duty.
That's correct. It's important to clarify that while inheritance itself isn't subject to transfer duty, we still need to apply to SARS
Why?
to get formal confirmation of this exemption. It's a procedural step.
Ah, okay. Makes sense.
And one more, if the property is located within a homeowners association, a clearance certificate from them confirming that all levies are paid up is also necessary.
Okay, so municipal, SARS, and potentially HOA clearance.
Precisely.
So once all those clearances are finally in hand, what happens to the actual title deed of the property? How does that change hands?
That's when the expertise of a conveyancing attorney becomes essential. They take over the task of drafting all the legal documents required.
The conveyancer.
Yes, they draft the documents needed to officially change the ownership of the property on paper, legally.
What kind of documents are we talking about here? What does the conveyancer prepare?
Well, key documents include things like a power of attorney that authorizes the transfer to take place, also a formal declaration signed by the executor, and that all-important transfer duty exemption certificate we just talked about, the one from SARS, and, of course, the original title deed of the property itself.
Got it. And finally, to make the transfer truly official, these documents need to be lodged somewhere, right? They don't just sit in a file.
Precisely. The conveyancing attorney is responsible for lodging all these prepared documents with the deeds office for registration.
The deeds office. That sounds like the final hurdle.
It is. This is the final step in legally transferring ownership.
How long does that registration process typically take? Are we talking weeks, months?
Generally, the lodgement and registration at the deeds office can take around 6 to 8 weeks. It can vary a bit, but that's a reasonable estimate.
Okay, 6 to 8 weeks.
Once everything is reviewed and approved by the deeds office, a brand new title deed is issued. And this new deed now reflects the beneficiary as the legal owner.
Fantastic. So that gives us a really good overview of the steps involved, step by step. Now, a question we often get, and you mentioned it earlier, is about the costs associated with all of this. What are the main expenses people should be aware of?
Absolutely. Understanding the costs is crucial for anyone going through this. One of the first things people think about is transfer duty.
Right.
And as we touched on, if the property is directly inherited by an heir, there's generally no transfer duty payable. That's a key point.
But what if the estate sells the property instead?
Good question. If the estate decides, or needs, to sell the property to a third party, then standard SARS transfer duty rates would apply to that sale transaction.
Okay, so inherited likely no duty, sold duty applies.
Exactly.
What about the legal fees? Those must be a significant part of the overall cost.
They are, yes. There are two primary types of legal fees to consider here. First, you have the executor's fees.
How are those calculated?
These are typically calculated as a percentage of the gross value of the estate. The law sets a maximum, currently up to 3.5% plus VAT.
Okay, up to 3.5% plus VAT on the gross value.
Correct. Then you have the conveyancing attorney's fees. These are for handling the actual property transfer part.
And how much are those, typically?
Well, conveyancing fees can vary depending on the property's value and the complexity of the transfer itself. But generally, you could expect a range from, say, around our $10,000 upwards of our $50,000, sometimes even more for very high-value properties.
Right, quite a range depending on the property value. Are there other fees besides these main legal costs?
Yes, there are definitely other potential expenses to budget for. We've already mentioned the municipal rates clearance certificate fees, and these will vary. They depend on the specific municipality and, crucially, any outstanding amounts owed on the property.
So that could be a variable figure.
It can be, yes. Then there are the deeds office lodgement fees themselves. These are the fees charged by the deeds office for registering the transfer. And those are?
They typically range from approximately R1,000 to R4,000, again, usually depending on the property's registered value.
Okay. And what about those advertisement costs you mentioned earlier? When do those come into play?
Right, the advertisement costs. These are applicable to estates with a total value exceeding R250,000.
Over R250K.
Got it. In these cases, there's a legal requirement to publish notices.
Where do they get published?
Usually in the Government Gazette and in at least one local newspaper circulating in the area where the deceased lived. The purpose is really to inform the public about the deceased estate and allow anyone with a potential claim against the estate time to come forward.
I see. And the cost for that?
These costs can range roughly from about R600 to maybe R2,000, depending on the publication rates. It's all part of ensuring transparency in the process.
It definitely sounds like a process with many moving parts and I imagine potentially a few bumps in the road.
That can happen, yes. What are some of the common challenges or hurdles that can arise during a deceased estate property transfer? Things people should maybe be prepared for.
Unfortunately, yes, we do see a number of recurring challenges. One of the most frequent and often saddest is disagreements or disputes among the heirs regarding the inheritance.
Family disputes.
Exactly. These can cause significant delays and add emotional stress to an already difficult time.
Well,
Another common issue is holdups in obtaining those necessary municipal clearance certificates,
why would that happen?
often because there are outstanding debts on the property rates, water, electricity that need to be fully settled before the municipality will issue the clearance.
So unresolved bills can stop the whole process.
They absolutely can.
What other snags might people encounter? Any other common ones?
Well, missing title deeds can certainly throw a wrench in the works.
If the original deed can't be found.
Yes, if it's lost or destroyed, it requires a formal reapplication process at the deeds office to get a certified copy issued. This adds both time and, unfortunately, extra expense.
Oh.
We also sometimes see backlogs and administrative delays at the master's office itself.
That sounds frustrating.
It can be. While it's often outside our direct control as attorneys, it can impact the overall timeline for winding up the estate.
And what about the will itself?
Well, less frequently, but potentially creating major complications, are legal challenges to the validity of the deceased's will. If someone contests the will, that can halt everything until the challenge is resolved by the courts.
These all sound like situations where having experienced legal guidance would be incredibly beneficial, almost essential.
Absolutely. That's really where our team at Jonker Vorster Attorneys makes a difference. We've dealt with these kinds of issues countless times. We have the expertise to navigate them efficiently, to anticipate potential problems, and to work towards resolving them. Our aim is always to minimize delays and, importantly, alleviate stress for the beneficiaries during a tough period.
That sounds invaluable. Earlier, we mentioned some frequently asked questions. People often have similar concerns. What are some of the key ones you hear?
One of the most common questions, understandably, is about the timeline. People always want to know, how long will this all take?
And the answer is
As a general guideline, we usually advise that it can take anywhere from 6 to 12 months.
6 to 12 months. Okay.
But, and this is important, this is really just an estimate, it can vary significantly depending on the specific complexities of the estate.
Like those challenges we just discussed.
Exactly. How quickly we can obtain those crucial municipal clearances, the processing times at the master's office, any unforeseen disputes, these all play a role.
Another frequent question must be whether it's possible to transfer property if the deceased didn't leave a will. We touched on this, but just to confirm.
Yes, definitely possible.
Yeah.
As we discussed, in the absence of a will, the property will be transferred according to the laws of intestate succession. It follows a different legal framework, dictated by statute, but it absolutely allows for the transfer of the property to the legally recognized heirs.
Good to know. Who typically bears the responsibility for paying all these transfer costs we outlined? The executor fees, conveyancing, etc.
Generally speaking, the costs associated with the property transfer are paid from the deceased's estate itself. They are considered administration expenses.
So it comes out of the estate's assets.
Usually, yes. However, there can be specific situations or perhaps instructions left in a will that might alter this. So it's something we always clarify up front with our clients based on their specific case.
What about a situation where the deceased co-owned the property with someone else? Maybe a spouse or a business partner. Does that complicate the transfer?
Yes, co-owned property can definitely introduce additional layers of complexity.
How so?
Well, the way the property was jointly held is key. For example, whether it was held in joint tenancy or as tenants in common under South African law will determine how the deceased's share is treated within their estate and how it passes on. It requires careful examination.
Right, so the type of co-ownership matters significantly.
Very much so.
And what if the appointed executor isn't moving things along? If beneficiaries feel things are taking unreasonably long, do they have any options?
That's a valid concern we sometimes hear. If there are genuinely unreasonable delays caused by the executor's inaction, beneficiaries do have potential legal avenues they can pursue through the master's office or the courts.
Okay, so there is recourse.
There is. However, we always find it preferable and often more effective to first try and resolve such situations through open communication and perhaps negotiation, if possible. Legal action is usually a last resort.
Makes sense. Finally, a practical point. What happens if there are still outstanding debts on the property itself, like a mortgage bond?
Right. Any outstanding debts secured against the property, with a mortgage bond being the most common example, will need to be addressed.
Address how?
Typically, these debts need to be settled before the final transfer of ownership can be finalized. This is usually handled by the executor as part of the overall estate administration process, either by paying off the bond from estate assets or potentially making arrangements with the lender.
Okay, so debt settlement is part of the process too.
It has to be.
We trust that this deep dive has given you, our listener, a much clearer picture of the deceased estate property transfer process here in South Africa. As you can hopefully see now, it's a process with numerous legal and administrative steps. It's not always simple. Having expert guidance like the support we offer here at Jonker Vorster Attorneys is truly invaluable in ensuring a smooth and legally sound transfer. It really helps to minimize those potential delays and complications along the way. If you are currently facing the transfer of property from a deceased estate, please know that your colleagues here at Jonker Vorster Attorneys are ready to provide the expert legal assistance you need. We are committed to guiding you through each stage with professionalism and, importantly, the care you deserve during what we know is a difficult time. Maybe consider this. Just understanding the general framework of this process, as we've discussed today, can empower you even when things feel overwhelming. What aspects of this process now seem perhaps a little less daunting than they might have before you listened? For further assistance and personalized advice tailored specifically to your situation, please don't hesitate to reach out to us at Jonker Vorster Attorneys. We're always here to help you navigate these important legal matters.